the elements of the case story that people are going to recreate all have things in common. It's a natural process. It's been going on. There are some people that say that we're wired for narrative genetically. But whether we are or not, there are basic elements, basic pieces of all case stories that people are going to reconstruct, and the one that you're offering them. The more you can line your delivery up with the way they want to hear and see it, the better. Today, the one key element I want to talk about is sequencing. The sequence of everybody's case story has certain things in common and certain things that can run astray. Everybody redoes it according to their own needs, but there is a generic outline I can offer you for structuring primarily a plaintiff's case story today. Every story has 3 steps, whether it's in the Bible, whether it's in Greek mythology, whether it's Shakespeare, whether it's a television show, whether it's a movie. Every story in human affairs can be broken down into 3 basic steps. These are so generic that they apply to plaintiff or defense cases. The first step is setting the scene, the context. The second step is the conflict or the action that takes place in it. And the third step is the resolution, what happened to the characters, and, in the case of legal decision-making, what you would like the decision-maker to do about everything. Those 3 steps are a way of organizing the case story you've got, the facts and the law and the persuasion all together. The thing you need to understand most about how to do that is to appreciate what frames are and how they work on people's minds a little earlier than just listening to the language. Frames are the key topics or reference categories that all those life experiences are clumped together in. Everybody has them, everybody shares them, and what I'm going to show you is how you can take a couple of frames per step in your 3-step case story and have a basic generic outline to sort through the evidence, the witnesses, what you need to bolster, what you might need to cut when it comes to planning the delivery of a case and not just the development of it. So let's get started. Here's the first step. How do you set the context? Many trial lawyers want to jump immediately to the rules, especially since the great book, Rules of the Road, has been out, and a lot of people have had a chance to take a look at it. If you haven't, I highly recommend that you do. It's a nice, simple, systematic way of creating rules that come out of the defense witnesses' mouths under oath that you can walk into court with, you can walk into a mediation with, and do great work with. However, if you're looking at a lay witness or a professional witness, they don't necessarily buy into the rules no matter who testified to them unless they've got some skin in the game. The way to do that is to point out what risks exist, what hazards exist, what threats to me and mine, as well as the people in this story, should I be relating to that justify having a rule to go along with it. Why do I need a rule? What risk is there that I can identify with? Finally, and this is the best part for expert witnesses, the third frame you want to set up for the first step of your story is the right way. If there was one piece of advice I could give anybody in terms of presenting a case, no matter what the venue, this is it. You always want to help people go through, in the face of the risk, under these rules, what does it look like? What does it sound like? What does it feel like? What steps would be taken? If it were done properly, you don't have to name the plaintiff. You don't have to name the defendant. All you do is go through a generic step-by-step under these circumstances, what it would look like had the rules been followed and the risk been blunted. Then you move on to the second step, and you show them what the defendant did instead. Then you show what that caused, and then in certain cases, especially medical cases, you may need to show them that there are no alternative causes. Notice on the bottom, evidence, testimony, and exhibits show up under each one of these frames. The point here is that these frames come first. People do the story first. They perceive of the message and the messenger. They recreate your story first, and then they will apply or filter out evidence, testimony, exhibits, anything else. Any evidence you bring them, any testimony you bring them is going to be filtered out, distorted, generalized, or deleted based on what story they've already begun to construct in their heads. The frames come first. Last but not least, in certain cases, you need to inoculate the plaintiff. That is, take care of whatever warts are on the plaintiff's case or on the plaintiff's character but after you've already accomplished the first two steps. Then you place a cash value on the losses as the evidence is going to show them. And last but not least, you make an effort to show up the defense excuses to the extent that you can. So there you have it. 3 steps, 9 frames, a generic plaintiff's outline for any presentation of any plaintiff's case. That will work for very, very many of them, but not in every case. I've already pointed out a couple of things that you can take out or move around. For instance, the very last 2 frames under Step 3 oftentimes need to be reversed. Depending on the judge and the venue, you can't do any attacking of the defenses. So all of this needs to be adjusted based on the needs that you've got. But if you follow this basic generic outline for how to sort out what the decision makers are going to hear, what the decision makers are going to see, you're going to have a much easier time of delivering a case as persuasively as it was developed. And all the resources and time and money you put into developing it don't get accidentally knocked out because the sequence was all screwed up for the decision maker.